We are live and on the record. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth. Draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Thank you. And good morning, everybody, and welcome to the Massachusetts Appeals Court virtual session for October 27, 2021. As you know, this is we just called this argument to hear this one case. The usual rules apply, 15 minutes per side. Once it's your turn, Attorney Faulkner, a clock will appear where the clerk was and doing the countdown to 15 minutes. You're free to use all your time, but no need to use it all if you're finished. There's no penalty for finishing early. Your panel today is me, Greg Massing, together with Justice Jeff Kinder, who's on the telephone, and Justice Eric Nyman. And I'll call the case, which is 2020 P-155, Commonwealth versus Thomas Babcock. Attorney for the appellant.
May it please the court. This case is a one-issue case. It simply boils down to whether the certified prior conviction was admissible or inadmissible, whether it was authentic or inauthentic. There was a bench trial as to this issue. He had stipulated he pleaded guilty to the original OUI. So the OUI second was based entirely upon this record of the Merrimack District Court in New Hampshire. And at trial, there was motion in limine practice. There were cross motions. The defendant, Mr. Babcock, claimed that the authentication of this record did not suffice to comply with the rules, in particular Rule 40. But the rules that apply to this are a combination of General Laws, Chapter 233, Section 69, Rule 39, and Rule 40. And what these rules require is essentially a double certification. So not only that the records are themselves authentic, which is the normal rule of admissibility for documents within the Commonwealth, but that they bear a double certification, which is under Rule 39, essentially that it has to be a seal of the court. Under Rule 40, that it has to be signed by a judge or an officer having a seal of office, and that's what we don't have here. The two certifications that matter most are reproduced in the record, in the brief at page 8 of my brief, and I believe it's page 17 of the record appendix, is the affidavit that goes along with Exhibit 2, and that is an interesting affidavit because it's got a space for clerk / assistant clerk / judge / custodian, and it's not signed one way or the other, but it is stamped.
Well, let me interrupt you there, Mr. Faulkner. I'm looking at that. That's record appendix page 17, and it does say Lynn Kilkelly. And then when we go to the next page, every page thereafter, there is a stamp that says a true copy attest, Lynn Kilkelly signature, and underneath it says Lynn R. Kilkelly clerk. So doesn't that clarify for us that it is the clerk who is bringing the affidavit?
It does clarify that and again, this is not a signature, it's a stamp, but the stamp Lynn R. Kilkelly does appear to be the clerk, at least as according to the attestation on the following page.
I'm sorry to interrupt you, but having examined a copy of the document that was submitted, there actually is a stamp that is raised on all of the pages of the prior conviction.
Well, there's a couple of issues with that. Number one, I'm not sure if you're referring to the stamp of the Lowell District Court certifying the authenticity of it, or if you're referring to the stamp of the Merrimack Court, which is the Lynn R. Kilkelly stamp. And obviously, the circular stamp of the Lowell District Court, which is added to show that it's a certified copy, although I believe probably is not on the exhibit that was transferred to the appeals court. But again, the stamp of the Lynn R. Kilkelly, even to the extent it appears to be a normal stamp. So when Your Honor says that it's raised, I'm not sure exactly what that means, as opposed to simply that it's the ink itself is somehow raised above the page. With regard to going to the issue of the stamp itself, the Commonwealth argues two things. Number one, they argue that these records were indeed under seal, but there's nothing that indicates this a seal of the court as opposed to this stamp by the clerk. Secondly, there's nobody that says that the clerk is the person who is in the custody of these records. Now, the Commonwealth says that argument wasn't made below, but that argument appears in the transcript at page 5, that Mr. Babcock specifically argued the certificate may be made by a judge of the Court of Record of the District Court or Political Subdivision in which the court is kept, authenticated by the seal of the court. And that's the authentication that's not here. So there's the first level. This attestation is the first level, but that second level that's talked about in Commonwealth versus White is what's not reached here. So this is not a record in the Commonwealth of Massachusetts. If this came from a Massachusetts court, the certification that appears on pages, I believe it's 18 through 22 of the record appendix, that certification would be sufficient if this were out of a court of the Commonwealth of Massachusetts, but it's not. It's a Commonwealth, it's a court out of the state of New Hampshire, which requires this heightened authentication. And there's nothing here that wouldn't be present in a normal document. So this double authentication record requirement would really mean nothing if this certification were acceptable, because it's nothing more than a normal certificate of authenticity.
Do we need a double authentication or double certification under Rule 39A and under Chapter 233, Section 69? Or is that just under 40A1? So
that requirement traces to Rule 40A1, but these being official records, I believe they still have to meet the requirements of Rule 40. But even assuming...
The reason I ask is because Rule 40C provides, this rule does not prevent the proof by any other method authorized by law of the existence of an official record. So it would seem to me that Rule 40C is saying, hey, you can look to other statutes and other rules in order to authenticate these documents. The double certification requirement under 40A1 is one means of doing so, but there may be other means.
I think that is potentially true, but when they say that in Rule 40C, I think what's had in mind is the clerk of that court comes in to testify, I did this search, and can authenticate it. In other words, other than a certificate
what's your authority for that proposition you just stated? Because I don't see that in Rule 40C, and I don't see that in any case law interpreting 40C.
It's not so much that, but I don't know that there's a case that says that, but it says that it has to be done in accordance with some other law. And Rule 39 it speaks to court records, but Rule 40 talks to proof of official records. So this is an official record. And so, yes, you can prove the authenticity in other ways that are provided by law, but I don't believe Rule 39 provides an alternative to Rule 40. But even assuming...
I'm sorry, Attorney Funk, I'm just looking at rules together. Isn't it a reasonable interpretation that Rule 40 is a more general for any type of record from a department or an agency of another state, or whereas court records are specifically addressed in Rule 40? it seems to me because we tend to, we give full faith and credit to judgments of the other states, and a court record seems to have more formality than maybe a zoning board record.
So I don't agree with that interpretation, but assuming that interpretation were correct, there's still an additional certification requirement in Rule 39, and again, that is that these records be under the seal of the court, and that's again still absent here. So there is no seal of the court on these records. Again, it's just the stamp of the clerk saying that she's the clerk, but it doesn't identify specifically that these are records of the Merrimack District Court. And every case cited by the Commonwealth, and I'm looking specifically at the Portland, Maine case, which I had also cited, but all of these cases cited by the Commonwealth involve cases where the records were indeed under seal of the court. So just a moment. And I'm looking specifically in the Commonwealth's brief at page 14 and looking at Commonwealth versus Key. Again, in Commonwealth versus Key, the same issue is that these records were under seal of the court. And that's what we don't have here. So I think that's the distinction between this case and some of the other Rule 39 cases when we're both looking at both Portland, Maine, and we're looking at Commonwealth versus Key, is that we don't have a seal of the court in this case. And that's, while Massachusetts gives full faith and credit to records of other courts, one of the reasons why we need a seal of the court is we need to know that we're giving full faith and credit to the records from a court of another jurisdiction, as opposed to something else. And we're familiar here in Massachusetts with our own certification requirements. But the seal of a court is what gives this court and courts in the Commonwealth of Massachusetts the confidence that these documents are indeed what they purport to be. And that requirement is there for a reason, because the courts of the Commonwealth don't typically deal with records from New Hampshire courts or Alaska courts or whatever state it is that we're talking about. And so that's why these requirements are there. I would suggest that for all the reasons cited in my brief, the attestations in this case don't add up to that. And again, this is the only evidence of that prior conviction. So unless there are other questions, I would rest on the briefs.
Yes, I have another question. So are you representing to us that on the documents submitted, the exhibits submitted at trial, and again, I'm speaking about the New Hampshire records, that there wasn't a seal of the Merrimack District Court on each page of the records over the true copy attest Lynn Kilkelly clerk stamp?
I don't believe that's so, but I don't have the original exhibit. If your honors have the original record exhibit and it does display such a seal over it, then I guess I stand corrected. But as far as I recall, and I was the trial counsel, the only raised seal is that of the Lowell District Court. And if you look at page 17 of the record appendix, we can see where the Lowell District Court has certified it as a certified copy. And I believe to the extent that a seal appears on any further copies, that's the seal of the Lowell District Court.
I'm looking at page 22 of the appendix, and at the bottom left, over Lynn Kilkelly's signature or stamp there, I can make out a circle that looks to me that's typical of a kind of stamp that that you see on these documents.
I believe that's the backside of a Lowell District Court stamp, Your Honor. And if you look at page 21, which is the reverse page of that, again, you can see that the Lowell District Court language is there in the bottom right-hand corner of the page. And then the reverse of that page is page 22.
Okay.
Thank you.
If there are no further questions, I would rest on my brief.
Justice Kinder, you have anything?
I do not.
Okay. Then thank you, Attorney Faulkner, and we'll hear from the Commonwealth.
Thank you, Your Honor.
May it please the court, my name is Casey Sylvia. I'm an assistant district attorney for the Commonwealth, assistant district attorney for Middlesex, appearing on behalf of the Commonwealth. First of all, I would just say my understanding is that there is a raised stamp on each of the documents. Obviously, Your Honors have the exhibit in front of you, or will have the exhibit in front of you when you're in the courthouse, because we transmitted it. That is my understanding in speaking with my colleague who prepared the brief, who I'm standing in for today because she is on parental leave. But obviously, I think that that's up to the court to ultimately decide, because you will have the exhibit in front of you.
Is it your understanding that that is the Merrimack District Court stamp?
That is my understanding.
Or the Lowell District Court stamp, as your brother understands it to be?
My understanding is that is the Merrimack District Court stamp. There is a Lowell District Court stamp as well, but I just would note that in the transcript, I believe that there's commentary about the raised seal that can be found on each page. And I don't think that the Lowell District Court seal would have been there at the time of trial. I would imagine that the Lowell District Court seal was affixed later on. Typically, we wouldn't have a copy of an out-of-state conviction or an exhibit certified by the local clerk until we were, for instance, preparing the records for some other purpose. But again, this is, I think it's up to Your Honors entirely to examine that exhibit and decide. I'd also just point out this actually was not raised below, I don't believe. There was some discussion.
No pun intended.
Sorry. Good point. So waiver does apply, and a substantial risk of miscarriage of justice would apply here. I would just suggest that the judge appropriately found that the New Hampshire court records were in fact properly authenticated. And I would also point out that the Commonwealth and the defendant moved under Rule 40. But I would note that it appears to me when I read the statutes together, when I read 233-69 and Rule 39 and Rule 40 and the Massachusetts Guide to Evidence, it appears to me that 233-69 is really what applies to out-of-state court records, and Rule 39 appears to follow that statute. When you read the case law, pretty much all of the case law analyzes out-of-state certified prior convictions under either 233-69, which has been around since the 1800s, as far as I can tell, and Rule 39, which of course is from 1979. I do think that Rule 40 applies more generally to other records. And I think that the way to read just other official records, such as RMV records, for instance, in the case law, Rule 40 appears to be what applies. But I think the way to read those rules in that statute together is to look at the catch-all in Rule 40, because I do think that that 233-69 or Rule 39 are any other method authorized by law. So I would say, though, in any event, what this is about is this is about authentication. It's about whether the item in question is what it purports to be. I don't think that this is a situation like the Duramo case in which there's some genuine question about authenticity, about whether this truly is a New Hampshire, a Merrimack District Court record or not. Obviously, as you know, in Duramo, the issue was in part whether or not the records were the same. The original and the copy appeared to have very material differences, and that's just isn't the case here. So I think that it's important, especially when what this case is being argued under is a court rule as opposed to a statute that appears to control, is to look at the purpose of that court rule, and the purpose is authenticity. And I don't think there's any suggestion or any reason to believe that these records are anything but authentic. And to the extent that there's issues that the defense could have raised at trial or did raise at trial, I think that those go to the weight rather than the admissibility of that conviction. I'd also just point out that as we did in our brief, that the clerk was sufficiently identified as the custodian of the records. Lynn R. Kilkelly is identified as the clerk of court on every page of record except the first page, and the affidavit is signed by the same person. I'd suggest that the stamp does not need to appear on every single page. There's a recent unpublished case from this court, Commonwealth v. Mejia, which is similar in the sense that it says that a stamp doesn't need to appear on every single page. So I would suggest, and that cites to Martinez Guzman and actually Duramo as well. So I would suggest that that's not necessary. Secondly, I just say within the context of the case law and the affidavit itself that it establishes that Lynn Kilkelly, the clerk, was the keeper of records for these purposes. The case law establishes, I think, very clearly that a clerk is a custodian of records. There are numerous cases going back to, I think, 1935 or earlier that make that clear, that a clerk is a custodian of records. And also under New Hampshire law, the clerk is a custodian of records, and this court can take judicial notice of New Hampshire law under the case of Commonwealth v. Key, which dealt with a fairly similar issue. And third, I just say finally that the clerk's stamp signature was a sufficient attestation under the controlling case law. Martinez Guzman, I think, really controls in this situation. And it says in the absence of a statutory directive, a signature may be affixed in many ways. And one of the many ways it gives us an example is in fact a stamp. There's an unpublished decision that follows that as well, Commonwealth v. Jackson, and says exactly the same thing with regards to Florida records. So I would suggest that the stamp signature was sufficient under our case law in the absence of any statutory directive.
Isn't there statutory directive here under Chapter 233, Section 69?
Did it be handwritten?
No, that it be under seal.
I mean,
233, Section 69 says the records and judicial proceedings of a court of another state, if authenticated by the attestation of the clerk or other officer who has charge of the records of such court under its seal. So isn't that statutory authority requiring it to be under seal?
I think I agree with that, Your Honor. And I think ultimately you do have the exhibit for that reason to determine whether or not it is in fact under seal. But my understanding is that there is a raised and printed seal if of the New Hampshire court. If I turn out to be wrong about that, I do apologize, but that is my understanding, having consulted with my colleague that prepared the brief in this case. But I do agree. I think that there does need to be a seal under 233-69, under Rule 39, or under Rule 40.
I took the cheap opportunity to make the joke there, but what issue are you saying exactly is waived? Because I mean, clearly there's a discussion of the admissibility of this at the hearing.
There's discussion of the admissibility of it. I don't think that there's discussion of this issue with regards to whether or not there needs to be a double seal. There seemed to have been an argument in the defendant's brief, and forgive me if I misunderstood, but about whether or not there had to be a separate seal of the court as opposed to a seal by the clerk. And I don't believe that argument was raised below. I believe the other arguments were raised below.
Okay, just wanted to clarify that.
Your Honor, if there's no further questions from the panel, I would rest on my brief and just ask that you inform the conviction of the Lowell District Court.
Justice Kinder, can't see you.
I have no questions.
Okay. Well, Attorney Sylvia, Attorney Faulkner, thank you both for participating on this. I'm sorry we couldn't do it in the courthouse today, but maybe that's just as well for you guys. I don't know.